This is the Decibel and Docket podcast. Welcome to Decibel and Docket, the podcast at the intersection of the music business, live entertainment, and the justice system. I'm Dave Brooks, veteran entertainment reporter, formerly with Billboard.
And I'm Mike Seville, attorney and avid fan of the entertainment industry. As a former journalist and now practicing attorney, I hope to shed some light on issues that insiders may not be looking at. And from the start, look, I am not soliciting clients. Nothing I say is legal advice, nor creates an attorney-client relationship. I'm just here to provide some legal commentary, education, and hopefully crack some jokes at Dave's expense.
Today, we look at AXS's lawsuit against Secured My Pass, a New Jersey tech company creating so-called counterfeit tickets that actually work. Officials at Secured My Pass say their technology is no different than fan printing a ticket at home. So what's the problem? We also tackle Merlin's licensing agreement with Udio, ending what one executive called the era of scrape everything and sort it out later. Now that the technology is becoming licensable, what does it mean to create an artist-friendly AI company? That's all coming up on today's episode of Decibel and Docket. So, Mike, as you can see, I actually changed things up a little bit here at my home studio. I decided, to clean it.
Good for you. It looks dope.
Thanks, man. I rearranged things a little bit. This is temporary. Kristen is actually going to help me kind of create a permanent background that looks pretty cool. But I was at least able to take what I have and clean it up better so you don't see all the crap on the sides. That was really distracting me last time I was editing it and looking at all the crap everywhere. So I cleaned it up a little bit, and I zoomed in.
Cleanliness is holiness, and now you just got to do your bedroom, bathroom, and kitchen.
I think the phrase is cleanliness is next to godliness.
That's probably more accurate.
So, Mike, I know you've traveled the world, you've been everywhere, but did you know that ticket scalpers have their own annual convention every year in Vegas and Nashville?
I did not, but that's pretty wild.
Yeah, it's called the National Association of Ticket Brokers Conference, and it usually features a couple hundred scalpers and ticket sellers, or as they prefer to be called, I guess I shouldn't say the S word, they prefer to be called ticket resellers or brokers. And they come together.
I was going to ask about that. I was like, is scalpers in the title of the convention or what?
No, they hate scalp. They hate the word scalping. And, that's why I like to say it, but just to piss them off. But, scalping, I mean, obviously has some kind of negative connotations, right? And that's what the brokers have pointed out too. They're kind of basically saying it's not very PC to call them scalpers. It kind of has connotations to Native Americans, which I kind of can understand and see. But, so to keep it PC, I will do my best the rest of the show to refer to them as either ticket resellers or brokers. Perhaps you might have a ticket reseller in your life and you don't know what to get them for Christmas, Well, a couple of years back, an undercover group representing the National Independent Talent Organization, that's independent managers and agents, sent some other delegates to one of these ticket conventions. And what they found was a convention floor packed with products meant to give ticket resellers an edge over fans like you and me as we tried to buy tickets for popular shows like Sabrina Carpenter or Bruno Mars, in a really busy on sale, right? Some of these products they have include like special web browsers that ticket brokers can set up so that each tab shows a different IP address. That way they can be logged into multiple accounts on Ticketmaster. Or they have these kind of virtual credit card apps that bypass, geographic restrictions on tickets and allow people to make a transaction with 10 credit cards at once as they try to gobble up tickets, right, to resell, right? All these kinds of tools. But now there's a new tool, according to this lawsuit, which I had never heard of before. And as you read the lawsuit, it's this little app. It's called Secure My Pass. And so what Secure My Pass basically does is that it makes copies of digital tickets that are really only supposed to exist, right, as an uncopyable file inside of an app. And it basically finds a way to spoof or copy them to make it easy to send tickets around to clients, right? It basically defeats the key feature of digital tickets that's supposed to make them unscalpable, unresellable, untransferable. And Access is suing over that, right? So my question to you is, like, you've had a chance to look at the lawsuit. What is what is Access's legal argument for suing Secure My Pass, and how is what they're doing different than me, printing out a ticket at home?
Well, that's a good question. And I think it's a complicated case, having reviewed it and done some research around it. Essentially, what Access is alleging is trademark infringement because the tickets that these digital, almost instantaneously created tickets, so with the evolving barcodes, still has the Access logo on it. So Access is arguing that that is a trademark infringement, essentially using the Access logo and identifying materials without their permission. So that's the first part of it. The second part is a breach of contract claim. Attorneys love to nerd out on breach of contract because we're trained to read and negotiate and execute agreements. And if those agreements are then not adhered to, or an opponent may find gaps or omissions in the contract, they tend to exploit it. And so Access is arguing that Secure My Pass is violating terms of the agreement that they reached, which allows Secure My Pass to access data and regenerate these third-party links in a way that the original contract did not contemplate or allow for. They also argue consumer harm, which kind of goes to the heart of these kinds of lawsuits. Access is alleging that customers are harmed in multiple ways. In the lawsuit, they cite ticket holders who attempted to go to see a Paul McCartney show or a Lorde show, and that if these tickets are being cloned, that sold multiple times to multiple people, the first people who go to the concert are the ones who get in, and the others aren't. Now, Secure My Pass has come out and raised some pretty interesting and I think noteworthy arguments. The first one being ownership v. access. And this kind of goes to a bigger issue, which I think we'll dive into later, but they're arguing that access is creating a monopolistic attempt, monopoly, common theme in a lot of these kinds of cases, but to force all resales through their own platform where access collects the additional fees and the markups on the tickets from the original prices. And second, Secure My Pass is arguing that the tickets are real, that they're not being spoofed or cloned. And they allege that Access is working with the venues themselves to deny access to tickets that are not being shown through the Access app. And that somehow they're going out and talking to all the people that, work at the ticket gates and the entrance gates, and that if they see a ticket that's not on the Access app, but on a different app, to deny entry, which they counter argue is harming customers.
Right, because I'm sure Secure My Pass is knows, yeah, some nefarious actors, will make copies illegally, right? But the majority of people not getting in is because of a decision made by Access to deny them entry, right?
Well, that's what Secure My Pass is alleging.
Right. Yeah. So the reason they're not getting in is not because the tickets aren't working. It's because Access has made a decision to look for these tickets and deny people entry.
That's what Secure My Pass is alleging. This is a very recently filed case, so there's not a lot of back and forth that we can dig into. But that is what Secure My Pass is saying. And, we will wait to see as the case develops whether or not that's true. And if it is, what are the legal ramifications for that? That goes to the more core legal argument of, whether a ticket is a piece of property that a person owns, Or is it a revocable license to enter a building? And this is like the really fun stuff, Dave. This goes back to some older lawsuits, and epic battles between, that AXS and Ticketmaster have brought against StubHub and things in the past, arguing that tickets are not property. They are revocable licenses to enter, because when you buy a ticket, you see your terms of service and like the restrictions and these kinds of things that are attached to the purchase of the ticket. And this kind of goes into a theory that two different sides hold as to whether or not the tickets are transferable or not. And the explosion of the secondary market for ticket purchasing is something that AXS, Ticketmaster are certainly aware of and know that there's a lot of money on that side. And so by creating their own apps, they're trying to lock in some of that money that exchanges hands on the second hand transfer of these tickets. And this didn't used to be a problem. Go back to your original point that you raised at the opening. I remember as a kid, my dad bought tickets for us to see a Dodger game. It was a big deal in our household. Had to drive 2.5 hours to Dodger Stadium. We get there, and the tickets were for another day. And we were, got a shit out of luck, except for the fact that there were individual resellers, we will call them, standing out in the parking lot selling tickets. And yes, they were more than the face value of the ticket. And that's how that reseller made their delta or profit on the exchange. So, I look at it from both the legal standpoint and the interesting points that both sides raise, but also try to envision, like, is this better for us? Is this better for the artists who are not getting cuts, I'm sure, of that secondhand retail of the tickets? And be interested in your take on it.
It depends on, your perspective. In some ways, the idea that, if I'm say I'm in New York City and there's a concert happening by like Harry Styles, let's say, and I want to go to see Harry Styles play. Well, right, like I know that I can go no matter what. The only limit is how much I'm willing to spend for those tickets, right? I mean, you can always go. So basically, every event is always accessible. It's just a matter of how much you're willing to spend. The secondary markets really give us a lot of data and insight on like what the concerts are actually worth to fans, and it gives all kinds of information that we can use to gauge what actual real demand is like, which is helpful when you're in a sales and data role. Now, of course, the flip side to all of that is that I'm not necessarily sure it's healthy for a marketplace to have a layer of speculators sitting on top of every show and transaction, and who are buying up tickets for resale for every single event, and they don't really offer any added value at all besides the fact that they beat me to it. I'm not sure that's a positive for consumers, right? Because it starts to create this perception that all basically it's a rigged market, and that that concerts aren't affordable, when the reality is that a lot of shows are, and that like most of the shows, it's only, we hear about resale so much because the high demand shows have resale markets. Most shows you can usually get tickets to without paying a high resale market. Just like it's like with the Warriors, right? The Warriors tickets are only jacked up multi times in price when the Warriors are good, right? If they're not that good, then the tickets are usually priced much lower, and you don't hear people kind of complaining about it. The AXS and Ticketmaster, they're in the resale business, right? So they have a huge incentive to sell the ticket themselves. That's part of the problem with all the ticketing is that the ticketing companies are incentivized to actually resell you the ticket, themselves.
They want to double dip and triple dip. Yeah.
Right, they get a double and triple or quadruple dip. They can charge like 20% of the original transaction in fees. Mike, you mentioned to me earlier, what we're kind of getting into here kind of has parallels to some of the other things that's going on with Live Nation, the antitrust lawsuit, FTC lawsuits. Have you looked into that as well? Is there anything you can tell us about that?
The long kind of wide web of ongoing litigation. You have DOJ v. Live Nation, which is a really big case, which I think is set for trial pretty soon. And you have FTC versus Ticketmaster. You have Fanimal v. Ticketmaster. And these are all kind of regulatory agencies coming after, and Fanimal v. Ticketmaster is two private parties. But do you think DOJ and FTC, you're talking regulators coming after ticketing companies and promoters, Live Nation, people that put on huge shows that draw a lot of interest. And so the federal government certainly has taken an interest in this. And, it'd be really to kind of see what happens both on the regulatory side and in the private party sides of how these kind of cases kind of evolve the activities and practices of companies and what the government thinks is fair, if you think the government plays by fair rules these days. But it'll be really interesting to see kind of how these larger kind of cases evolve and develop, and then how that impacts the private parties that are kind of fighting over trademark infringement, breach of contract, those kinds of things.
The ticketing companies have in some ways made ticketing so complicated that there's demand for products like this out there because the security measures that they're currently using just make it really difficult, right? That said, I don't like all these tools. I don't like the spoofers and the credit card and the VPN address hiders and all that stuff. And my fear is that, this is all very short term. It hurts the overall business, right? People do not think the ticket buying process is fair. They think it's rigged against them. They think that other people, especially brokers, jump the line, and they think that the ticketing companies, especially Ticketmaster, are in collusion with them. When you get stuff like this, it's hard to argue otherwise. Mike, this week, independent music licensing group Merlin announced that it was partnering with artificial intelligence platform Udio to license recordings for training AI models and for use within the Udio app. Music Business Worldwide is reporting. That gives Udio access to Merlin's enormous client base of indie labels like Sub Pop, which famously, broke Nirvana, as well as Epitaph, home to Bad Religion and The Offspring. Merlin controls a huge share of the indie market, with working with record companies over 70 different countries. It's said to represent 15% of all global recorded music. This partnership follows the settlements Udio reached earlier last year with Universal Music Group and Warner Music Group. Both major, companies sued Udio for copyright infringement, but dropped their lawsuits after reaching these licensing agreements. As part of this agreement with Merlin, Udio is able to develop AI systems using music from Merlin members who can choose whether or not to participate. And the idea is that compensation will flow back from Udio to participating artists and labels. We don't know a ton about this deal, but do you think this kind of agreement protects artists, or is it just delaying bigger problems that'll rise up in the future?
Well, I think it depends. I think that it can protect artists, but we have to remember, the kinds of artists that Merlin is representing. A lot of them are up and comers. A lot of them don't have a lot of bargaining power and leverage in securing a deal with a label. And so if you're a struggling musician or an emerging musician and Merlin says, "Hey, we'll sign you, but you have to check this box that we, are allowed to use and, share our music with Udio." And that means that, AI models will be trained and allowed to use your music in ways that you cannot control. Is that protecting the artist? Do they have leverage? Are they equal partner in that deal, in that original signing of a label agreement? That does not contemplate nor kind of address what happens with existing clients for that label or artists who have already signed with Merlin. And what if they say, "No, we don't want to"? Then what? If this is gonna be a big part of Merlin's business strategy moving forward, and Udio's partnership is part of that, what's more valuable to both Udio and Merlin? To have artists who say yes? What about the ones that say no? And so I think it does give more protection to the artist than they had before, but I think it is creating some bigger issues in the future. And, I'm interested to know, like, who does Udio sell their music to? And, and what kinds of companies, industries are interested in that music that will use it in an AI kind of generative format. There are unsavory businesses out there. What if they want to use the music? Can the artist say yes or no to each time someone wants to sample or use their music? Or is it yes, you can use it and no, you can't? Is it blanket kind of agreements? I think there's a lot to kind of shake out here. But I think this is a natural progression of the settlements that occurred with some of the bigger players last year. I mean, we're talking Universal, we're talking Warner. These are big, big groups. Merlin, my understanding is typically represents, kind of lesser known or smaller artists who have less leverage, less maybe options to sign with a label and might have to take it. And then what?
Right, right. Like you're saying, it's not totally clear how they're going to fit these music catalogs into their business model. What we do know, there was a great article on Billboard by Kristen Robinson kind of on this recently, and she has something I did not realize this. Udio began as a generative AI music company, right? So basically, you have the app and you tell it, hey, make me a country music song about a Bandit the dog, my dog, right? And make sure you include a banjo and in it and a drum solo, and it would basically come up with that, right? With his music knowledge kind of coming from having been trained on all this recorded music. Now they're going to change that, according to Robinson, right? Now, what Udio is going to pivot towards remixing and customizing current music from UMG's catalog. And she said that it's actually going to relaunch as a new service with only licensed songs from label partners going forward. So what I take that to mean is that I'll be able to take an existing song, say Waiting Room by Fugazi, and in my phone I'll say, give me a neo soul version of Waiting Room by Fugazi that sounds like it's being sung by Kurt Cobain. Right. Now, I mean, that's kind of how I'm imagining it, which, I'd listen to that.
Yeah, that'd be
But,
cool.
You're right. What is the monetization model for you? And I'm assuming they're going to have to charge users like a monthly fee or run advertising to make money, right? And what's to stop? And then what's to stop them from licensing like the music to Hollywood studios and television commercials and film franchises like the Fast and the Furious? It seems just like we really don't really know a lot about this stuff, right? So that in mind, I want to ask your advice here. So let's say you're representing an artist, right? And their label signed a deal with Udio. How would you advise them about learning about how their music is being used?
Yeah, I mean, I think a good agent or attorney that was representing or advising an artist would have a whole host of questions. And this is kind of like goes to my former point or previous point is we just don't know. The AI world is evolving so fast, so rapidly in so many different ways, largely unregulated. I would advise a client to really spell out, and any good lawyer would do this with any contract negotiation, is you try to create no ambiguous terms, no ambiguity as to the application of the terms. And so I would want a clear understanding with Merlin in this case. Who is with my genre of music, what are the most typical cases or most commonly used cases that Udio users are going to focus on and use to manipulate the music that, my client is producing? And I would want it all kind of known. I think transparency is the key here. How are there restrictions on who can use this music? Are there restrictions on how many times a particular song can be used? And I would want to know how Merlin, will be compensated for that and how my client will be compensated for that. And then in the age of digital music, exposure is key. My understanding, and you know more about this, but artists make most of their money in concerts now, not on album sales and not on Spotify or Apple Music downloads. So exposure is good. And if my client has a catchy song that is being utilized by Udio, does Udio note who the original producer of the music is? And that can drive interest and popularity of a musician. And so even if it's manipulated or transformed in some way, that might get more earballs listening to music that they know originally came from an artist represented by Melville. And oh, hey, guess what? That artist is going to be on a nationwide tour, and they're coming to a venue near you. Like I would want to really spell out how this could be mutually beneficial for both parties, or all three parties in this case, the artist, the label, and Udio. And I'd want a clear understanding of how that would all work. And I'd want my client to fully understand what they were getting into and not have it sorted out later to the extent possible.
Reporter's notebook. So, Mike, yesterday, news broke that one of my old bosses at Billboard, I'm not going to say her name. If you want to know, you can easily look it up, is leaving journalism and is going to take a new job at Warner Music Group as the head of communications, reporting to the company's CEO, Robert Kinsel. If you follow the music business at all, you probably know that Warner is the smallest of the three major labels, right? But it is home to some powerhouse imprints like Atlantic Records, which, is a label for Bruno Mars, Ed Sheeran, Charlie XCX, and is run by two well-known Nepo babies. Not my term, okay? This is from a Hollywood Reporter article, but I don't think they would even argue with the fact that they're Nepo babies, right? Elliot Grange, whose dad famously runs competing label Universal Music Group, the largest of the big three labels, and Val Blavatnik, whose dad is Len Blavatnik and is a majority shareholder for WMG. And when I mean majority, I mean he owns over 70% of the stock. So he's also the controlling shareholder, and he's Kinsel's boss. Okay. So, got that out of the way. So now it's been reported in a number of outlets, like the Hollywood Reporter, that Elliot and Val want Kinsel's job. They're basically, at the head of one of the smaller labels. And according to Ethan Millman, who's a great reporter, a number of executives, the talk in most music companies and most circles, he had a quote that sums it up. He said, Lynn Blavatnik, the majority owner, Lynn will throw his kid in the seat as fast as he can. It's succession. Warner is like, according to this guy, a vanity asset from Lynn, who is a billionaire and has made his fortune across energy and various other non-music sectors. So keep in mind, right, Kinsel is an outsider. He's the only major music CEO in the business with a background in tech rather than music. And the company, it's a publicly traded company. The company's stock is down about 11% from its October high point. And we also know from reporting at the Hollywood Reporter that Kinsel updated his employment contract recently, shoring up parts of his severance package that deal with being fired without cause. Okay, so to me, walking into a comms job while you basically reporting to a CEO who may or may not be getting into a open battle for his job might prove to be difficult, especially if Grange and Val Blavatnik are really gunning for the CEO spot, like many media outlets are reporting, right? I mean, this would be a difficult job for any experienced communications person, right? Let alone somebody with no communications experience, but who has a journalism background and has not worked in comms before. So that is a hell of a job to undertake. And all I can say to them is good luck, and maybe talk to you soon.
That'll be interesting to follow, Dave.
I am going to be eagerly reading all of it.
Yes, me too.
All right, that concludes, Mike. Another episode of Decibel and Docket. Mike, you got any plans coming up for the weekend or ahead?
Sleep and discovery responses.
Man, sleep sounds
Work,
good.
Work
Discovery
and sleep.
responses
That's
not
what I'm
so
hoping
fun.
for. No, it's not. Part of the job.
So I got one more joke for you before I let you go. How do you track Will Smith in the snow?
I don't know, but I'm nervous to ask how.
You look for Fresh Prince.
Nice.
All
Glad
right,
it wasn't
Mike.
a joke about him punching someone on stage in front of a million.
Yeah, no,
million
this is
people.
not that kind of show. All right, Mike, have a great one. I'll see you next time.
Peace, DB.
You've been watching the Decibel and Docket podcast. Please like and subscribe and tell your friends.